All right, guys. Sorry we're running late here. Sorry that we're running late here. Just one more second, guys. One more second here. All right. Okay, so TikTok over here, if they decide that they don't like what we're saying and restrict the account, you can come over to my YouTube channel. We're live on YouTube right now, or you can go to Facebook. We're live on Facebook, or you can jump over onto at Justice Without Limits. We're also live there. And so this is also being recorded. This is also being recorded, so you can go back to Facebook. You can see it. You can go back to YouTube. The full video will be recorded on both of those platforms, as well as also we'll break it up into TikTok so that you guys can see the video. So there's a few things that I want to talk with everybody about on where we're at, and I want to point something out to everybody because as I think it's important. That is that a lot of these videos that I make, there's a very specific audience for it. You got to understand that, right? There's a very, very specific audience, and I'm not necessarily making the videos for you guys. In a lot of cases, I'm making the videos for them, right? Because they need to know exactly what is going on. They need to know exactly the situation. They need to know exactly, what they're facing here. Because again, like I've said numerous times, the least destructive way to be able to address this situation is for them to concede, right? And work together to fix the problem, okay? So that is my goal, you guys. And I still believe that we can reach that goal, but you got to understand that that's what I'm trying to do, okay? I'm trying to get us to where they will concede because they understand and can see the totality of the situation, and they do the right thing. And if they won't, then of course, then we'll do it for them. And I have no problem with taking that route if that's what's necessary. But the least destructive way is that they will address it on their own. So a lot of these videos that I make are not necessarily for you guys as much as it's for them. Okay. So anyway, for what that's worth, you guys, look and consider the context of the video and consider the fact that I'm moving forward and I'm not asking for any permission. I'm not asking for anybody's direction. I already know what we're doing and I already know how to do it, and we're getting it done now. All right. So, so 1 second here. Let me jump on Facebook. So another little housekeeping thing here, you guys. Please, please, please don't say anything stupid, especially over here on TikTok, because I know that people like to come in. They like to make statements that gets this restricted, the video restricted. If you do that, you're going to be blocked. I don't have time for anybody being stupid or saying stupid things. I don't have any time for working against us. And we all know how this government works. They attack the character because they can't attack the argument. We know that that's what they're doing. Right. And so just understand that if you come in here and you start attacking me and my character in any sort of way, you're done. You're blocked. You have no need to be in here. I have no time for any negativity. We're moving forward with what's positive, and that's that. All right. So please don't come in here just making statements. Now, another thing here is that some of the things that I'm going to say here could be offensive politically. Right. Just understand, I am not here for political reasons. I could give a shit about who the people decide to put into power. I could give a shit about what political aisle they're on. What I care about is the rights of the people and the sustainability of our nation, which means the preservation of that which makes our nation a nation. So some of the things I'm going to say here with regard to where we're at and what is going on in the larger picture could be offensive to some people. And I apologize now if that would be offensive, but I need you guys to really consider what I'm saying here, and I want you guys to think about it, because you guys need to understand. You seriously need to understand what is really going on, okay, and why it's happening, okay. None of this is about attacking any political party or any candidate or any. This is about letting you guys know exactly what's going on so that you can understand, because it's very important that you understand, because if you understand, then that means that we're going to be able to work together to resolve the issue, okay? So some of the things I'm going to say here could be offensive, and I apologize if you're offended by it, but just understand that I'm telling you guys the truth so that you can understand it, and we can figure out how to get a workaround in. All right? So all right, so where are we at right now? Well, we've got a lot of affidavits, you guys. Just so that you guys can understand, we're looking at 13 pallets of paper right now. I mean, it is an absolutely insane, and we're not even done putting them all into boxes, but each pallet has got 40 boxes on it, and we are looking at around 13 pallets, which is way more than I ever dreamed or thought was going to be possible, but that's how much we got, right? So we reached out to the United States Supreme Court, to the clerk of court. We're trying to get a date to be able to deliver that, because it's way more than the guard shack can receive, and that's how you're supposed to deliver it, right? And so, you know, they did balk about that a little bit. They thought, well, this is too much, right? And that they don't have any place to warehouse it. Well, I really don't care about your warehouse. We can do it one of two ways, clerk of court. We can either, one, you receive it all at once, or two, we'll do it one at a time at your guard shack, and we'll spend the next 3 or 4 days there doing it. And, you know, I would really prefer doing it all at once, but the clerk of court has to receive each one of these, right? And the way that they receive it today is from the guard shack. So you would go to the northeast corner guard shack, and you would go to there. They would take the paperwork, they put it in a little plastic envelope, and then they fill out a little receipt card, and they take that receipt card and put it onto it, and then they would hand carry it down, and that's how they would receive it. So they have to receive these. They can't deny it. So, you know, like I said to them, that they can either receive this all at once, or we're going to have to sit here and do this for 4 days, you know. And so we need a date and time to do it. But this is way more than I ever thought was going to be what we were looking at. So that being said, we have additional costs that are coming into it. Guys, please continue to donate. We're not done with this yet. We are not done. All right, we're close, but we're not done yet. So please continue to donate. If you guys don't know, We Shall Be Free, your Cash App, Chime, Venmo, PayPal, they're all exact the same as We Shall Be Free, okay? We're going to have a panel truck, 20-foot U-Haul to be able to get him there, and we're going to have to spend half a day offloading it. And that's going to be a pretty exciting day that I think will, you know, if the news won't report it, then I would pray that a lot of you guys will show up there with your phones, and we'll do our own reporting, kind of like we did last week. All right, but it's a lot. So we don't have a date on that yet, because we can't just show up there with the 20-foot U-Haul and say, here is what we got. Okay. All right. So another issue came into play, guys. You guys know that we're doing a writ of habeas corpus. Okay. So what is a writ of habeas corpus? A writ of habeas corpus is a writ that challenges an unlawful detainment, right? A detainment. It's used to challenge an unlawful detainment, right? So if your arrest was unconstitutional because they didn't have an indictment by a great jury required by the Constitution of the United States, which is necessary to hold someone over, right? Because the Constitution says no person shall be held to answer for a capital or impious crime without an indictment by a grand jury. So if you got arrested without having an indictment by a grand jury, that would mean that your detainment was predicated upon an unconstitutional act, So in this particular instance, what you would do is you would challenge the unlawful detainment. And the mechanism that's used to do that is a writ of habeas corpus, right? You see, back in 1925, the United States Congress confused the people of the United States, and they made you think that writ of habeas corpus was used to challenge or used to provide the federal court the ability to be able to appeal. A writ of habeas corpus is not an appeal. It's actually the exact opposite of an appeal, right? Because the purpose of the writ of habeas corpus is to challenge the arrest, not challenge the judgment. But most people got confused in 1925 of the purpose of the habeas corpus. The purpose is not to give the federal court the authority to be able to appeal something. The purpose of the writ of habeas corpus is to challenge the unlawful detainment, right? Detainment. So once again, if we're going to address 700,000 prisoners that are currently incarcerated without lawful authority because the states didn't have the proper paperwork in place to be able to perform those arrests, then we would need to use the writ of habeas corpus, okay? That's what we have to use. That's the mechanism, okay? Now, likewise, with the child issue, listen to me, you guys. The right of intimate association. This is something that I haven't talked about, but we need to get this out on the table as well because we need the court also to think about it. We know the court's watching all these videos. They're closely following what I'm doing and saying, which is awesome and great. But the thing is that the right of intimate association, which is the right that was enacted or that was incorporated by the Supreme Court in 1984 under the Roberts versus United States case, which says that you have the right to have an intimate familial relationship with your child without governmental interference, and your child has the right to have an intimate familial relationship with you without governmental interference. What you need to understand is that right went two different directions. That right went from mother to child, and it went from child to mother, right? So the problem here is that when the state said, you know what, we're going to take your child away, they needed to have two different adjudications going on at that moment because they had to have one to determine and to remove the child's right to be a child, but also the mother's right to be a mother. There had to be two separate cases because there's two different rights. There's the right for the child to be a child, and there's a right for the mother to be a mother, but that child never received due process to deem that child unfit to be a child. This is the sticking point that I've been hanging on to, because every single child that has been taken from the love and care of their families has been without due process because there was never a hearing for that child. Okay? There was a hearing for mother, maybe. There was a hearing for father, maybe. But there was not one for the child, which means that child has been detained by the state unlawfully. Thus, writ of habeas corpus becomes the mechanism to address this issue. Writ of habeas corpus is used to challenge an unlawful detainment. When your child was taken into state custody, that child was detained, just like an adult is detained and taken into state custody. It's no different. It's the same action. So the state has taken your child into custody, right, through a detainment, but we now need to challenge the validity of that detainment by saying, where was the hearing for that child? Where was the hearing to deem that child unfit? Where was the hearing to remove that child's rights? There wasn't one, okay? And as a result, we are challenging all of these children's detainments by the state without due process and lawful authority because there was never a hearing to deprive them of that right, okay? So the habeas corpus is what we're using. It's the correct mechanism to use, right? Once again, I've been through this. We are not appealing anything because there isn't anything to appeal, right? Because the court didn't have authority to do it. Because of the jurisdictional issue under Article 3. So, but we need to find the proper mechanism to use. So it can't be a writ of certiorari. because a writ of certiorari is used to challenge a judgment, right? It's a claims processing relief. It is an appeal because it's a request to review a lower court's decision. We cannot do a lower court's decision because there is none, right? Where's the lower court decision in your child's removal? Your child never got a decision. Hell, they never even got a court case. There was never a case that's associated with that child and that child's right to be a child. So the state interfered and deprived a person of a fundamental right without any hearing, without any due process, without giving him opportunity to be able to challenge the hearsay accusation against him. Therefore, what we're doing is the proper mechanism, the writ of habeas corpus, not a certiorari. The problem is that on Sunday, you guys, I was in Washington, D.C. at the Grant Memorial, standing in front of the Capitol, and I said, you know what? Here we go. Tomorrow, we're going to be delivering this. Tomorrow, we're going to be coming out, and we're going to be stepping up and starting this process of holding all these states accountable for the crimes they've committed, right? When I got back that afternoon to our Airbnb, the President of the United States had federalized National Guard troops. I think we all know about that, right? We all know that he federalized National Guard troops, and he sent those National Guard troops that were state of California National Guard. He federalized them under his authority and sent them into California. And he stated during the press conference, he said that he's doing this because we're in a state of rebellion. And that word rebellion is extremely, extremely important or extremely applicable. That wasn't some arbitrary word or term that he used. That was a specifically placed word for very specific purposes. You guys need to know the purposes. Constitution of the United States under Article 1 says that the privilege of habeas corpus shall not be suspended except for in cases of actual rebellion. Okay? Except for in cases of actual rebellion. That's pretty telling. Because the first step to get us into the state of rebellion is federalizing National Guard. Right? National Guard hasn't been federalized since 1920, right? When they federalized to deal with the Japanese encampments. Prior to that, it was the Civil War, right? Doesn't happen very often. The state of rebellion as well is important because that is the one condition that the Constitution says that the habeas corpus, which is the mechanism we're using, can be suspended. Can be suspended. So they can take away the writ of habeas corpus. And what happens then? Well, court doesn't have to hear it. Habeas corpus has been suspended. Don't have to hear it. Case dismissed. Go away. We don't have to do anything about this. That's a very, very scary situation now, right? Because we're bringing a habeas corpus. Because they knew that we were bringing the habeas corpus. Because I told them and showed them that we're bringing the habeas corpus. They've had it since 2023. And then the day before we plan on delivering this, the president federalizes the National Guard and says that we're in a state of rebellion. If we deliver this now, right? That's why I didn't deliver on Monday. They didn't get delivered on Monday. Because if we deliver this on Monday, when the president's saying we're in a state of rebellion, we're done. We just shot ourselves in the foot, right? This was not an accidental move, right? These protests are not without purpose, you guys. Because what we're dealing with here is literally going to shut this government down. It's going to remove and eliminate their revenue stream. 700,000 prisoners, 12 million children. CPS can't take children anymore. This is their bread and butter. And they want to continue business as normal. We know that because I've served 47 state attorney generals and 47 state Supreme Courts with notices of this going on, and they've chosen to just ignore it and continue on business as normal, you guys. Right? So So the problem is that they're positioning themselves with a way to get out of this. They're not working on a way to get through this, even still, right? So we got to be very, very tactful here. So I'm working on an argument, because the truth is that the people of the United States aren't in the state of rebellion. It's the government that's in the state of rebellion. How can government suspend the privilege for the people, right, when it's the government that's in the state of rebellion? It's the government that's not following the procedures and processes codified in the Constitution of the United States in the adjudication of crime or the removal of children. That's on them. They're the ones that are in a state of rebellion. This isn't about immigration, you guys. Although we could talk about immigration, what I'm saying here is not about immigration, but they're using this immigration situation to bring this conflict so that they can put us into this state of rebellion once again. So that they can suspend the habeas corpus, justify it the moment that we submit this. Because there's no way out of it. There's no way that they can get out of this except for we don't have to hear it now. That's the same tactic that the United States Supreme Court used in 1857 with Dred Scott versus Sanford. Right? Back then they were dealing with slaves. Dred Scott, he was in a free state and said, well, I live in a free state. I'm subject to free laws. I'm free. So he brought his writ to the Supreme Court and said, hey, I'm suing for my freedom. I want to be free. All right? The Supreme Court said, oh, shit, if we rule on this, we're going to have to set all the slaves free. We don't want to do that. So they had to find a way to make it so that they didn't have to hear the case. They didn't want to hear it. So what did they say? They said that blacks are not people, and as a result, only people can bring a case in federal court. And now guess what? Mr. Scott, you're dismissed. Go away. We don't have to hear it. And now we don't have to release the slaves. And we're in the same situation right now today, where we're literally standing here on the precipice of the release of all the slaves. Because we know that the 13th Amendment made synonymous the term criminal and slave. They mean the same thing. A criminal is a slave is a criminal under our laws. So if that's true, and we're dealing with the criminality and the prisoners, well, guess what? We're about to release their slaves. They're looking at a Dred Scott number 2 from 1857 to 2025 right now, and they're saying we don't want to release our slaves. They make us a lot of money. So history has this tendency to repeat itself, you guys. They have this tendency to repeat themselves. Let me tell you a little bit more about history repeating itself. This goes back again to Dred Scott. Because I've said numerous times to you guys that once you identify the tactic of the tyrant, then you know that their actions are always the same. Right? Their behavior is always the same. The delivery might be different, but the tactic remains the same. So in 1857, Dred Scott versus Sanford came forward. Okay? And in that case, again, Mr. Scott was a slave. And he was brought from his slave territory into a free territory or a free state. And he said, well, I'm in a free state now. How can I be enslaved? I'm in a free state. So he sued his slave master in the Supreme Court and said, hey, I want to sue for my freedom. The question that he asked the Supreme Court of the United States was, can slaves sue for their freedom in federal court? Can slaves sue for their freedom in federal court? Well, that's a pretty easy answer. Yeah, they can. Okay, great. I'm suing for my freedom. But that was the question that Dred Scott asked. Can slaves sue for their freedom in federal court? Again, the Supreme Court of the United States, led by Chief Justice Taney, a disgusting American, right? A traitor at best, sympathizer to the South and the slavery institution, right? This was the precursor to the Civil War. This was what started it, you guys. I mean, this was the final straw. It was the precursor to the Civil War. This was it. So Taney, he comes out and he says, well, to bring a case to a federal court, you have two things have to be in place. One, you have to be a person. And two, you have to be directly impacted by the laws in question. directly impacted by the laws in question. Okay. So they couldn't say that the slave laws didn't apply to him because he's a slave. He's here suing because he's a slave. So the laws applied to him. They couldn't challenge that. The Supreme Court couldn't deal with that. So they had to say, well, you have to be a person to bring a case in the federal court. So how do we make Mr. Scott not be a person? Well, they did it this way. So first off, they said that slave and citizen are synonymous. Those two terms mean the same thing. If you are a slave, person and citizen. They said person and citizen are synonymous. So a person is a citizen and a citizen is a person. Those two terms mean the same thing. Now notice, this is before the 14th Amendment. Everybody says that the citizen was created by the 14th Amendment. No, it wasn't. It existed long before the 14th Amendment. But nonetheless, person and citizen mean the same thing. If you are a citizen, you are a person. If you are a person, you are a citizen. That's what the court said first. Then they said that blacks are not and were not intended to be included under the word citizen in the Constitution. Blacks are not and were not intended to be included under the word citizen in the Constitution. So in other words, blacks are not and were not intended to be included as a person in the Constitution. Thus, you're not a citizen, Mr. Scott. Therefore, you're not a person, and only people can bring cases into the Supreme Court. Therefore, case dismissed. We don't have to hear it. Go away. All right? Dismissed the case, told him to go back and argue with his slave owner for his freedom. He was returned to an enslavement state, and thus he did later on win his freedom, but he didn't win it from judicial relief. Okay? But that's what the court did. And they didn't do that because that was the right decision. They didn't do that because that was the right thing to do. They didn't do that because that was equitable and just. They did that because they did not want to release the slaves because the slaves made their institution a lot of money. A lot of money, right? And so now that was the ruling. Blacks are people. Go away, Mr. Scott. And we don't have to release you, and it doesn't matter whether you are a slave state. What happened here is that the court created what's called dual sovereignty. Dual sovereignty, where you are a United States citizen and a state citizen both at the same time. Because if slaves are not people, are not citizens, well, they still live somewhere. Therefore, they only fall under the state laws, not the federal laws, right? Which is where we see the division between the state courts following the Constitution of the United States of America and not. This concept of dual sovereignty was created from this case, and now as a result, the federal court says, oh, we abstain. States can do whatever they want in their courts, right? But you don't get your federal rights unless you're in a federal court. You get state rights within a state courts, but you don't necessarily get them in both. Because, of course, Mr. Scott, right, he was in federal court, said, hey, I have the right to bring this case to federal court. They said, oh, no, you don't. So if he's not a citizen of the United States, he has to be a citizen of something because he's... So then that created the dual sovereignty concept. That you can be both a state citizen at the same time that you're a federal citizen, but you don't necessarily have the same rights in both, which is a completely bullshit concept, philosophy, and it's long been refuted, but it's rearing its ugly head once again right now, right? Right now, it still is ruling its ugly head. But if you're born protected by the Constitution of the United States of America, and it protects you no matter where you choose to reside within the jurisdiction of the United States, then how can a state deprive you of that when the state is subjected to that which they're depriving you of, right? State has no existence outside of the Constitution. So that's the history leading up to the previous Civil War. That's the history leading up to, to where we were, and we ended up losing 1 million lives, was that the federal court said, no, slave, go back and argue with the state, go back and argue with your slave owner. We don't have to hear your case. Dismissed. That was 1857, precursor to Civil War. Right? Now fast forward to 2019. In 2019, I prepared the writ habeas corpus at state of Washington. And I delivered the first writ to the United States District Court of Eastern Washington on April 10, 2019. Over the next 10 months, got over 4,000 people to file the exact same writ. Exact same writ. I wrote it. I wrote all the responses, everything. We did the exact same paperwork. The only thing that changed was the first 4 pages because that was unique to each person's individual case, right? I was building an army here, right? I was building a whole bunch of affidavits or affiants that would come forward in a massive attack, which is exactly what the NAACP did when they were dealing with Plessy versus Ferguson in 1958. This was the tactic that I used. Got over 4,000 people to petition over 10 months between April 10th and September 2019, or 8 months between April 10th, 2019 and September 2019. 4,000 people petitioned the United States District Court of Eastern and Western Washington. And you would think that you would all have heard about that, right? That's a pretty big deal. We shut down the United States District Court of Washington, both Eastern and Western, because we had so many writs of habeas corpus that were submitted challenging the absence of the indictment by a grand jury. Well, so immediately the United States District Court came back and they said, dismissed, right? Dismissed. We don't have jurisdiction. Go exhaust your remedies with the state. Go argue with the state, right? Sound familiar? Go argue with the state. Go argue with your slave owner. You don't have jurisdiction. So I came back on the rebuttal and I said, no, that's not true. That's not true because Title 28, subsection 1343, which is civil rights and elective franchises, that's a jurisdictional code, Title 28, subsection 1343. What 1343 is used for, what it's prescribed for, is to redress the deprivation of any deprivation of any right by a state or under state statute, ordinance, custom, or regulation, providing for equal rights of all persons within the jurisdiction of the United States. So again, to redress the deprivation of any right secured by the Constitution under state law, providing for equal rights of all persons within the jurisdiction of the United States. That's the right prescribed code. I'm redressing the deprivation of a right protected by the Constitution under state law. Therefore, this is the code to be used. This is the correct jurisdictional code. Now, under that code, you guys, you also need to remember that there is a bypass of the exhaustion of state remedies mandate. Right? They tell you to go and exhaust your remedies with the state. Go and argue with the state. Get a decision from the highest court in the state before you bring it in federal court. But that is not true if the state has a law which forecloses upon the petitioner's procedural situation. If the state create a law that says that they can deprive you of this right, there's nothing to exhaust, right? Thus, there is a bypass from the exhaustion of state remedies mandate right there under 1343. It's written in the law. It says you don't have to go and exhaust anything. It's been exhausted if the state has a law that forecloses upon the petitioner's procedural situation. Why would you go and spend one more second arguing with the state that's already created a law that forecloses upon the procedural situation? Thus, the law permits for the bypass. It's a bypass of the state exhaustion remedy mandate. Look it up, guys. Now, 1343, once again, it is used to redress the deprivation of any right secured by the Constitution under state law, providing for equal rights of all persons within the jurisdiction of the United States. Now, that law, right, 1343 being the correct prescribed purpose, it says the United States District Court has original jurisdiction of any civil action authorized by law to be commenced by any person. Okay? United States District Court has original jurisdiction of any civil action authorized by law to be commenced by any person if the purpose is to redress the deprivation of right under color of state law, right? So what is the correct code? So my rebuttal back to the court was no. United States District Court, you have jurisdiction because guess what? It says you have original jurisdiction of any civil action authorized by law to be commenced by any person. The habeas corpus is a civil action authorized by law, and I'm a person. And this is what I said to them in the damn rebuttal. And you know what Chief Magistrate Finke said? Finke was her name. This is public record, you guys. You guys can go out, you can look it up right now. You can go to the United States District Court, you can look at the rebuttal, the responses from the court. what that judge said. That judge said that ordinarily the district court has jurisdiction, original jurisdiction in this case, but that statute can't be used by state prisoners. I want you guys to think about what I just said for a moment, right? Think about what I just said for a moment. That the United States District Court has original jurisdiction of any civil action authorized by law to be commenced by any person. I submitted an original civil action authorized by law, and they said that state prisoners are not people. Because if I were a person, then they would have had to have heard it. They said ordinarily the district court has original jurisdiction in this case, but that statute can't be used by state prisoners. This is a repeat of the Dred Scott case. Magistrate Fricke made the exact same ruling that the Taney court made in 1857, which led to the Civil War. The precursor to it. Blacks aren't people, right? Slaves aren't people. Prisoners aren't people. Which was the ruling that I manifested in 2019. You guys you can all see it. The United States District Court said that slaves aren't people because only people are protected by that law. So if prisoners aren't people, right? Because that's the decision they made in 2019. That's what we manifested. Then they said blacks aren't people. They said slaves aren't people. All these three things are the same thing, you guys. Remember, the 13th Amendment didn't free anyone. It made synonymous the term slave and criminal. They're the same thing. A slave is a criminal, and a criminal is a slave. But the problem is that, yeah, I'm a person. I'm a person, and I can bring that particular challenge, because the problem with Magistrate Fricke's theory there was that law that is used to protect prisoners and to give them an avenue to be able to challenge in federal court their detainment. How can you say that a prisoner can't use the very law that was created to give prisoners a mechanism to be able to challenge their detainment? They just didn't want to hear it. But we can go directly to the law, you guys, because the Civil Rights Act of 1964 and 1968, it created some protections for prisoners. You guys know what those protections are? It specifically states that a state prisoner can in no way have their civil rights deprived or reduced or diminished, abridged, unless expressly stated within the law. Unless expressly stated within the law. Where in 1343 does it say anything about, oh, this applies to everyone except for a prisoner? This applies to everyone except for a slave? It doesn't. So Chief Magistrate Fricke, you violated the law. Because the law it delegated you jurisdiction, original jurisdiction. You can't say, go back and argue with the state, because the law delegated it to you, assigned it to you, and you don't have the authority to change the law. If you're going to take your obligation and say, oh, I'm going to give it to someone else, you're amending the law in an other than lawful manner, because judges don't change the law. This is the thing that you all need to understand here, is that judges do not change the Constitution. Hell, Congress doesn't change the Constitution. The president doesn't change the Constitution. It must be done in accordance with the will of the people. And according to our founding father, George Washington, that those obligations are sacredly obligatory upon all, both individually and collectively, until changed by an authentic and explicit act of the people. You know, someone asked me last night, they said, well, but original jurisdiction can only be brought to the United States Supreme Court by an attorney. That's what the rules of the Supreme Court state. I don't give a shit what the rules of the Supreme Court say. Do you guys care what the rules say? Because are rules law? Because what the law does say is that the Supreme Court has original jurisdiction of any case in which a state is a party. That's what the law states. That's what the Constitution says. So if there's a rule that says, oh yeah, but only attorneys can invoke original jurisdiction, that's not what the Constitution says. It doesn't say that. It says that so, if the court wants to change the Constitution, they want to change their obligations, that's fine. Present your case to the people and get them to agree to it. But if not, then you're altering the Constitution in other than lawful manner, which is the crime of sedition. I don't care what your rules say, Supreme Court. Your court is not restricted only to bar members, right? Because the Constitution didn't say that. Your court is subject to the people. But more importantly, the Constitution says in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So it's not the person that determines original jurisdiction. It's not the license that determines original jurisdiction. It's the case that determines original jurisdiction. And if the case is State of Washington versus me, that doesn't require anybody to bring that to you because it's the case, not the court, that grants jurisdiction. You can't create a ruling that abridges, amends, or modifies or restricts the rights of the people. Any one of you can bring a case to the Supreme Court. And if that case names a state as a party, that court has original jurisdiction assigned by the Constitution. No other court in the country can have jurisdiction. The other day when I was on the Fearless Floyd podcast, Fearless Floyd, it clicked to him eventually, right? It finally clicked and he's like, oh my God, that's why I keep on getting the response back from these courts that say petitioner fails to state a claim upon which relief can be granted. How many times have you guys seen that in your responses back in the court? Petitioner fails to state a claim upon which relief can be granted. Petitioner fails to state a claim upon which relief can be granted. Why? Because you're in the wrong court. If you go to the wrong court, you're failing to state a claim upon which that court can grant relief. They're not going to tell you why you failed to state a claim upon which relief can be granted, but that court can't grant relief because they don't have authority to grant it. Petitioner fails to state a claim upon which relief can be granted because only the court that has jurisdiction could grant relief. If I were to say to you, I want you to go over there and rob that person over there, right? Even if I'm your boss, you can't go and rob that person because ignorance of the law is no justification for having broken it, right? So if the Constitution of the United States of America says that in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction, that's the law. That's the highest law. That's the law that you must follow, and you must follow, and I must follow. Everyone must follow. Which means that if Congress comes out and says, United States District Court has original jurisdiction, then what you do then is that you rely upon someone else and what they told you to do, and then you go and you break the law because you submit to the incorrect court. If you rely upon that act of Congress and say, Congress, I'm going to believe you and I'm going to go break the law, then don't be surprised if the response you get is petitioner fails to state a claim upon which relief can be granted. You're in the wrong court. You need to go to the right court. You need to go to the court that has jurisdiction. And that means that you don't follow liars, right? You don't follow criminals. You follow the law, Constitution. What does it say? It says go to the Supreme Court. Okay, that's where we go. That's the law. We're going to follow it. We're going to do what the law tells us to do. So, my response to that individual this morning was pretty simple, is that, no, you don't have to be an attorney to go to the Supreme Court. That might be their rule, right? But rules don't matter when they conflict with statutes. Read the rules of civil procedure. Rules must not conflict with statutes, nor impair the legal rights of the parties involved. Thus, a court has no power to create a rule which would constitute a waiver of a constitutional right. If we have the right to go to the Supreme Court, right, then we would have the right to be able to go there without having to go through their mechanism, without having to go through the licensed agents. They can't restrict the right. They can't license the right. Murdoch versus Pennsylvania, right? Therefore, yeah, you could bring a case to that court. They have to hear it. And if a state is named a party, it is what it is. That's why these rules don't matter, you guys. They want you to bind the clip together. They want you to spend $1,000 wrapping all this paperwork. Why? Once I bring a case that says state of Washington versus whoever, they can't deny it because they have jurisdiction. It's the case and not the court that grants jurisdiction. They can't say, oh, we're not going to hear it because you didn't put it in the right binder. No, that's a willful disregard of an obligation. That's a rule. I don't have to follow your rules. I'm not subject to your rules. I'm subject to the law. And the law says that you must hear a case in which a state is a party. We are in charge. This is our court, not their court. This is our law, not their law. We got to rely upon it. Use it, leverage it, push it in there. Don't let them bring the bullshit in. Doesn't matter what Congress says. Doesn't matter what Congress created. Because anything that's in conflict with the Constitution is unconstitutional. So Congress says, yeah, you know, you got to bring a writ of habeas corpus. You got to bring a writ of certiorari. No, we don't. Just find a different route. Right? They say it's court of discretion. No, it can't be a court of discretion because you can never use discretion to abridge a constitutional obligation. So we destroy all these lower laws, all this bullshit, by simply relying upon the 4 pages of the Constitution of the United States. That contract right there is sufficient to be able to destroy these arguments that they're posing against us. All right, so once again, 1857, court comes out and says, slaves aren't people. They're not people. Therefore, you can't bring a case in federal court. Go back and argue with your slave owner for your freedom. 1857. 2019, state prisoners aren't people. Go back and argue with your slave owner for your freedom. You can't bring a case in federal court. History repeated itself. Right? We're on a cycle once again. Right? We had 1857. They said that slaves aren't people. 2019, they said that prisoners aren't people. And of course, the 13th Amendment makes synonymous the term slave and prisoner. So we're on the exact same path. And that's why I'm very, very nervous about the situation that we're in. I'm very nervous about what we're seeing with the protests. I'm very concerned about the agitation that's coming across these states, because I'm going to tell you right now, government does not want to give up their slaves. I don't care if it's the Trump administration or if it's the Supreme Court. None of them want to give up their slaves because their slaves is the basis of their business. Their business. And we know that, you guys. We know that. Because the highest rates of incarceration are red states. Okay? This, again, isn't about political party, because I'm going to tell you the blue states waste the money. They blow the money on programs that they say is there to help the poor, and yet they watch the poor sit and die on the street. That's not empathy, that's apathy, right? So blue states, you are absolutely guilty of stealing money, of wasting money. That's what you're doing. But I'm telling you right now, the red states, they love the business of government, and they are advancing the business because the highest rates of incarceration are in the red states. Texas, Alabama, Florida, Oklahoma. These are red states, and these red states are imprisoning and enslaving these people because that's what the business of government is in. Right? That's what they're in. So both sides of our government are both at fault right now. They're both at fault. But we need to understand this, because what I'm seeing out there is very scary, because we are on a path that's so incredibly similar to that which started the Civil War, right? Because they did not want to give up their institution. They didn't want to give up their slaves. And what are we asking them to do right now? Set the slaves free, right? I've been talking about the Jubilee. That's what I'm focused on, is let's have a Jubilee for this country. What's the Jubilee require? 2 things. Release the slaves, forgive the debt. All the debt that's owed to society, forgive it. Let's start over, because government, you can't break the law in order to create the debt. If you break the law to create the debt is fraudulent. So we have a serious, for real, a legitimate path forward to be able to do this. But what we're seeing right now is they have a path to block it. They have a path to block it. Because the writ of habeas corpus can be suspended in cases of actual rebellion. The president said we are in a state of rebellion, thus he's federalizing the National Guard and sent him out. So, sometimes, you all know I'm a believer. If you don't, well, maybe I need to work on my belief, but you all know I'm a believer. Lots of times the Spirit will do things, put stuff into place in order to help direct me in timing. It's not frustrating for me to encounter a block like that, because that's telling me it's not the right time yet. Not the right time yet. The right time is coming. It could be any moment, but the right time wasn't on Monday. But what we got to say to this government is that you're the one in rebellion, not the people. And you cannot suspend the law because of your rebellion and us wanting to hold you accountable for your rebellion. Again, this isn't about immigration. This is about the people of the United States and the rights that the people of the United States are getting denied, right? We can talk about the immigration issue at another time, but right now, today, there are 700,000 people currently imprisoned that have been denied their fundamental constitutional rights. That's what we're talking about, not immigration. We're talking about 12 million children that have been robbed from their families. That's what we're talking about, not immigration, okay? So I want to finish this, and then we're going to go into questions right after this, but I want to finish it with this. I want you guys to think about what happened in 2004, right, with a case called Rushul versus Bush, right? You guys know my background. I was intelligence, right, and in special operations military, Homeland Security. So what happened was that September 11th happened. Terrorist attacks happened. And then we went in and we had the Patriot Act. Patriot Act undermined and significantly eroded away the fundamental rights of the people, direct deprivation of the fundamental rights and the limitations of government. No denying any of that. So then what happened was they opened up this facility down in Guantanamo Bay, Cuba, called Camp X-Ray. And with Camp X-Ray, it was a detention facility where they would take enemy combatants, right, terrorist suspects, and they would take them down there and they would detain them, right? And so what they were doing was that someone would call up the agency, right, CIA, Homeland Security, whoever, and say, this person is a terrorist. Then the government would take that single set of information without verifying it or validating it or giving the accused the right to be able to challenge it. They would take that information and say, this is now our suspect, and we're going after him, right? They're going to go after him. So then they would go out and they would find him. They'd arrest him. And then they'd take them down to Guantanamo Bay, Cuba, where they would put him through these deprivation tactics, which would mess with them physically, sexually, emotionally. And the reason why we were doing that was because we thought for sure, we're like, we have the information on you. We know that you're a terrorist, and we just want you to admit that that's what you are, because we know, we got the information. And so we would put him through these tactics. We would put him in hardened facilities with no windows so they can't see the sun in the darkness, right? We would waterboard them. We would take their food away. We would make them have lights on 24 hours a day. We would have hot and cold heat fluctuations in the buildings. Does any of this sound familiar, right? Lights on all the time, hot and cold temperature fluctuations, sleeping on hard concrete without a mattress or a pillow or a blanket, right? Noise all the time, Buildings without windows, block walls. Does this sound familiar to any one of you? Because this is what we do in every single jail and prison across America, right? But that's what we would do. We would take them down there. We would put them through these deprivation tactics because we just wanted them to admit that they were, in fact, what we said that they were. And we would keep them there. We would keep them in that facility with these deprivation tactics until such time as they would finally admit that that's what they were. And when they were finally willing to admit it, after everything we've done, after they were finally willing to admit that this is what they were, yes, we knew it all along, then we would take them in front of a single judge advocate general who would declare them guilty in this sham process that we called justice down there. Right? Justice. Was it justice? Right? Was it a fair, neutral proceeding? No. Right? Was it constitutional? Absolutely not. Right? But this is what we did. We did it because hindsight now today, we can look at Guantanamo Bay, Cuba from 2004, right? And we know now today that most of the people that were sent there, they were not terrorists when they got there, but they were a terrorist when they left there. Because we were creating the very object that we were going out and fighting against in order to justify this war on terror, right? Because these tactics were designed to make you into the very object that we said that you were. That's what deprivation tactics are designed to do. So like today, if you were to go into a courtroom and the court were to say, you're not fit to be a father, right? You don't take care of your family, then they deploy deprivation tactics that's designed to make you not be able to support yourself, right? You have a whole bunch of fees, a whole bunch of fines, a whole, high child support. All these things are designed to make it so that you become the very object that they say that you are, right? So that they can say, see, I told you, he doesn't take care of his family because he doesn't make any money. He doesn't have a job, right? He doesn't have a car. He doesn't have a house, right? It's all designed to make you into that object that they say that you are through their deprivation tactics. Now, another deprivation tactic would be that they say that you're a violent person. Oh, this is a violent person, right? We arrested him because he's a high violent person. And then we put you into a jail where you are under extreme stress around a lot of other violent people, because that's what happens when humans are in fear, is they turn to aggression to protect themselves out of that fear, right? And what happens then is that eventually you become the very object that they say that you are, right? Because if you become the very object that they say that you are, if you become that aggressive person, then what happens is that you become the very object that they say that you are, so that they can justify their going out and fighting against you in this war on crime. Right? Pretty simple. So again, Guantanamo Bay. We were taking these enemy combatants. We were sending them down there. We were labeling them a terrorist, right? And we were telling the whole world, these are terrorists that we got down here, every one of them, and we're going to put them through these tactics that's going to hurt them. It's going to make them into the very object that we say that they are, because we know that they're a terrorist. Well, what happened then was the ACLU, American Civil Liberties Union, right? These heroes, they found out about this, and they said, wait a second now. Those enemy combatants down there in Guantanamo Bay, Camp X-Ray, they're being denied the fundamental right of being able to confront the hearsay accusations that are against them in front of a fair and neutral decision maker, third party, right? They're being denied that fundamental right to be able to defend the accusations against them. Well, that means that their detainment is unconstitutional, right? That means that they have been detained without lawful authority. So the ACLU stepped up in 2004, a case called Rochelle versus Bush. And they said, you know what? We're going to file a writ of habeas corpus on behalf of all these enemy combatants, all of them that are down there, because we know that they're being held in violation of their fundamental constitutional rights. They have been denied the right to be able to confront the hearsay accusations that are against them in front of a fair, neutral decision maker, which is also known as a grand jury. No, they weren't being they were being arrested based upon a single set of information. They were being detained, sent down there, put through this sham process where the judges acted as both judge and jury in this process. Where was the neutral decision maker in the process? That's what the ACLU brought up in 2004, brought to United States Supreme Court on behalf of all of these terrorist suspects, most of whom were not United States citizens. And you know what the United States Supreme Court decided in 2004? They decided that those enemy combatants, foreign nationals, they are all, every one of them, protected by every single right secured by and enumerated in the Constitution, because they are still subject to the due process of the Constitution of the United States of America. Right? Still subject to it. So the Supreme Court made the decision in 2004 that terrorist suspects are guaranteed the right to be able to go in front of a neutral, unbiased decision maker, third party, to confront the hearsay accusations against them in a fair proceeding prior to being detained. A grand jury. Every terrorist suspect is guaranteed the right to a grand jury. Supreme Court made that decision in 2004. And now here it is, 2025, and there's more than 700,000 United States citizens of this nation, protected absolutely by the Constitution of the United States and the rights enumerated within it, and they have been denied the right to be able to confront the hearsay accusations that are against them in a fair and neutral decision-making third party, a grand jury. 700,000 of them have been denied that one fundamental right that terrorist suspects were protected by the United States Supreme Court in 2004. And then this court is sitting here pretending like they don't hear or know about this, right? Pretending like nothing's going on. And yet they made this damn decision in 2004 for terrorist suspects, and they're continuing to obstruct and deny United States citizens the same damn rights. Question I have is, where's ACLU here? Why am I the only asshole out here fighting this, right? This particular issue. You guys are all fighting, I know. But where's the ACLU behind this issue? Right? Where's the NAACP behind this? They had no problem jumping up and helping enemy combatants and terrorist suspects in Guantanamo Bay in 2004. But where are they at today? Where are they at right now? Nowhere to be seen. I brought this to them. Hell, the Attorney General, almost every one of them is part of the ACLU, right? Members of it. Where's the NAACP, right? They talk about how there's an overrepresentation and radicalization of the prison systems that's targeting black people, and yet, where are they at on this? Why aren't they here organizing and getting behind this so we can help these people overcome their enslavement? The same thing that the terrorist suspects overcame in 2004. Where are they at? Do they care about their members? Do they care about their supposed mission statement? Where are you at, NAACP? You say that you want to help black people not be in prison. I've got a mechanism to get them out of prison. But I kind of need your help here, right? Because I don't have the bodies to be able to push this. I have 13 pallets of paper that I got to get from where I'm at now to Washington, D.C., and I don't have the money to do it. Where are you at, NAACP? If you're serious about what you say you're serious about, where are you at? Come on, we got a case now. We got something legitimate here. You can come in with this on a silver platter because it's done. Where are you at, ACLU? Where are you at? I brought this to you on the national front. I brought this to you on the state front. I brought this to you at least 12 times. And you guys have decided to just continue to ignore it. And yet you're going to push this immigration issue once again. Why are you constantly pushing foreign issues and foreign civil rights and not the civil rights of the people of the United States of America? Where are you at, ACLU? Get behind this. 2004, ACLU steps up, decides that they're going to fight for foreign nationals, enemy combatants, and their civil rights that are being deprived under our Constitution, but they have never stepped up to fight for the people of the United States civil rights protected under our Constitution. Never once. Never once. And what are they doing today? Well, this No Kings thing, ACLU is sponsoring it. ACLU, why are you fighting for foreign national civil rights when we have American civil rights issue that we need to get addressed right here today, right now? It seems as though you yourself are repeating the same narrative over and over again. Because the exact same thing that you fought for in 2004 for foreign nationals and terrorist suspects, I'm fighting for the people of the United States right here. And you guys aren't here helping. You guys are actually fighting against and drawing attention away from this when this is exactly what you say that you do. So I want you guys to understand the history behind this. This has been addressed. It's already been done. The Supreme Court of the United States has already made this decision. The Rasool versus Bush case is the exact same case that we're doing now. Only Rasool versus Bush dealt with foreign terrorist suspects. We're dealing with United States citizens, slaves, prisoners, criminals, whatever you want to call them, right? Slaves of the corporation, whom the ACLU clearly doesn't want to have their civil rights because that would be a detriment to their nonprofit organization, right? So you guys should know that, that's what we're faced with. Some of these things that you're seeing, these protests, they're being orchestrated because that's their way to get out of this, not their way to get through this. It's a distraction. And if we buy into this distraction, then what's going to happen is that they will suspend the privilege of habeas corpus. And if they do that, and I can't effectively argue that argument, then we're going to be stuck until such time as they decide to lift the restriction. So I'm going to go the exact moment that God tells me to go, right? I'm limited to what God is providing, and right now we're waiting. We're waiting to see what happens with this, with everything. With Senator Padilla being arrested yesterday, that's going to bring the legislature in. Now, once again, this is about parties. This is about look at the bigger picture, about what is God actually doing with everything, right? Because God's orchestrating it. He's behind it. He's permitting everything to happen. So we simply have to look at what he's doing, right? So we can understand the direction that he's leading us. If he's saying we're going into actual rebellion, that means don't submit the habeas corpus yet because they can suspend it. But the arrest of Padilla yesterday, Senator Padilla out of California, that's going to bring in a whole new set of argument. Because we need the legislature behind this. You guys, I keep saying that. The legislature needs to get behind this. They're responsible for dealing with this because the 14th Amendment transferred enforcement of this onto them. Well, now we've got a senator that gets arrested. Now we've got them coming in. And so I just want you guys to think about what's happening. I want you guys to look at it. I want you guys to know that we're going to go the exact moment that the time is right. But we need to be very, very cautious here. Because if we go too early on this, then they suspend it, and then we're done. All right, we're done, okay? We don't want to do that. Thank you, yeah. So So we don't want to go too early, guys. We want to go at the perfect timing, and we'll get there. We're gonna have the right time, okay? But once again, we need to prepare the argument that it's not the people that's in rebellion. It's the government that's in rebellion. Okay? It's the government that's in rebellion. So you can also go out to the website right now, Tanawah.com, and we put a clock on it. We put a clock on a week ago. So if you guys have been out there, you would have seen that we gave them 15 days. We provided notice to SCOTUS, and we said, we're coming in 15 days. We're giving you an opportunity to self-reflect and decide what you want to do here. So the clock is ticking. At 15 days, it'd be next Tuesday. We're going to need at least that much time to finish cataloging all of this paperwork, and we have to palletize it all. We have to have it on pallets, and we've got to raise the funding to be able to get this done, right? So that being said, let's talk about how you guys can help, okay? This is the last topic before I come into questions, all right? So as you guys know, I've been going around, I've been serving the city councils and county commissioners. I hope you guys understand why I've been doing that, okay? So the reason why is because the city councils, they prepare the budget and approve the budget for the city police, right? They pay the police, all right? Now, the county commissioners, what they do is they prepare the budget and pay the jails, right? The prisons, the prosecutors, and the sheriff, okay? So if the police are performing arrests on people without an indictment by a grand jury, that means that their arrests are unlawful. They're in violation of law. And you can never pay someone to break the law. That is the emolument violation, okay? That's the emolument violation. You can never pay someone to break the law. So when the city council pays the police and the police are not following their lawful obligations to have an indictment by grand jury before holding you over, then that means that these arrests are unlawful, which means that the city council is paying for these unlawful acts. Pretty simple, right? Now the sheriff, they're going out and they're executing warrants on behalf of the judge. Judge says, yeah, I want you to go and arrest this guy. They go and arrest this guy, and but if there's not an indictment, if they're arresting on information, then that means that arrest is also driving from an unlawful act, which means that the sheriff's actions are unlawful. And now it's the county that through the property tax is paying those people to break the law. Emolument violation. Now, likewise, the jails. If you are arresting someone without lawful authority and then you are holding them for ransom, that's kidnapping, well, that means that all of those jailers, the whole jail itself is housing people who are kidnapped and being held for ransom, right? And that's exactly what's happening. So the county commissioners are paying for kidnapping. They're paying for people to be held in ransom. This is the fundamental allegation that we have that's per se and hasn't even been rebutted by any one of these 47 attorney generals or Supreme Courts or senators. They're not arguing with it because it's happening. They can't deny it. Where's the indictment? There isn't one. Good. Your arrest is unconstitutional. Therefore, you are now kidnapping and holding for ransom that person. So if the county commissioners are paying for the jail and that jail is holding people ransom, that means commissioners are paying for these crimes, paying for kidnapping, paying for all the rest. Likewise, if the CPS agents are going out and taking children and depriving of a fundamental constitutional right, then that means that it is the county commissioners that's paying CPS to break the law, to steal children, because those children did not have a hearing to determine whether or not they can have that right taken. That's where we went back to the habeas corpus at the beginning. So understanding all this, right? Understanding all this, these county commissioners, city council members, maybe they don't know. Maybe they're not aware that the budgets that they're preparing to pay the police officers and the sheriff and the jail, maybe they're not aware of these crimes that they're committing. Maybe they're not aware that they're a part of the criminal conspiracy because it is their budget that's paying for these crimes. So I've been going around, and I've been randomly, whenever we were in a city where, or a location where there was a council meeting, city council, county commissioner, where there was a meeting, we would just go and I would provide a notice to them, right? Because every county commissioner meeting, every city council meeting, as long as they're a hearing, right? As long as they're a hearing, then you have the opportunity to be heard, right? And they give you 3 minutes. And as long as you are acting sane and, you know, and not vulgar language and whatever else, and they won't interrupt you, and you have 3 minutes, right? Because that's the parliamentary rules, right? 3 minutes. You have 3 minutes to speak, and they don't interrupt your 3 minutes. And if they do, then you yield your time back, right? It's parliamentary rules. You have that right. Every city council, every county commissioner meeting, as long as it's a hearing, you can go into it. Now, what's funny is that when I was in Birmingham, Alabama, right, and you guys can see these videos. These videos are on TikTok, they're on YouTube, they're on Facebook. You guys can go back. You can see what we did. Well, when I went into the city to county commissioner meeting in Birmingham, Alabama, that wasn't a hearing. It wasn't a hearing. That was a meeting. We were just there because we were going to the hearing right afterwards over at the city hall. But if you guys remember in that particular video, and all of them are recorded. They're all recorded. They're televised. This is notice. And you have all those people that are responsible for preparing that budget right there in front of you. Well, when they finished the meeting, before they adjourned it, because the moment it's adjourned is the moment that nothing is on record anymore. If you can get something out before they adjourn it, now it's on record, right? Now they have to. They can't say they weren't notified because it's all on record. Well, before the meeting was adjourned, they came out and they said, well, Joe, do you got anything else to say? And Joe looked at me and he said, yeah, well, there's this guy standing over here. I don't know who he is, right? But he's in this meeting. What's he doing? And they gave me the ability to be able to come out and say, and that's when I spent 10 minutes saying, well, you know what? You guys are paying for the jail, and they said, oh yeah, but that's not our problem, that's someone else's problem. And I said, yeah, but not if those people being held in that jail are there unconstitutionally. So my point here is that every single one of you, right, that wants to get involved and wants to help, there's over 3,000 counties across this country. Those are city council members, there's county commissioners. Those people also need to get served. And the more we get served in the next couple weeks, the better. Because we're bringing a whole lot of heat onto these public officials to say, are you going to continue to break the law? So I can't go around the country. I don't have the money to do it. We don't have the time to do it. And there's too many counties. You all have a county that you're in. You guys are all capable of doing what I've been doing. So what we're doing is we're preparing a script. Very, very simple script that anybody can easily read through in 3 minutes. If you guys want an example, it's going to be almost exactly what the city of Fairfax, what I said at City of Fairfax, okay? Because I still had 16 seconds left over. It was nice and slow, easy. You guys can go to that video. You guys can use that as your example, right? The City of Fairfax. So go to the City of Fairfax video, and you can watch it. And this is what you do. That was a hearing. And during the hearing, they always have public comment. So you're going to go there to public comment, and you're going to go in the most professional way that you possibly can. You know, wear your clothes and be a respectful person and whatever. And you're going to read the script. And it's important that you read the script because there's certain things that needs to be said. You need to say it's an emolument violation to pay someone to break the law. You need to say that and you guys were using the indictment issue. Do not go in and use the family issue because the family issue is not enumerated. You must use the indictment issue because that's enumerated. It is written, okay? So you're going to use the enumerated constitutional right of indictment by a grand jury. Clause 1 of Amendment 5 says no person can be held to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury. Every single state across the country has enacted a law that permits their prosecuting attorney to charge by information or indictment. That's a little tidbit that I have not shared with all of you. Every single one of them has created a law that permits their prosecuting attorney to do it because of a case called State versus Dunn. The United States Supreme Court came out and said, yep, prosecuting attorneys, you can use your discretion to decide whether to charge by information or indictment. Right? That's the same law or the same ruling as Hurtado versus California. Once again, you cannot create a law that permits a prosecuting attorney to decide who gets a constitutional right and who does not, because that would be a violation of the Equal Protection Clause of the 14th Amendment. You cannot create a law that directs your agent to break the supreme law of the land. That would be an emolument violation. You can't create a law that impairs the obligations of the prosecutor's contract that he entered into upon oath or affirmation, because that would be a violation of Article 1, Section 10, right? So State versus Dunn, it has no validity, but all 50 states permit their prosecuting attorney to charge by information or indictment by their discretion. That's what we're attacking. So what you're going to say is, Constitution says you got to have an indictment by a grand jury. However, this state has enacted an inferior law in its inferior constitution that permits the prosecuting attorneys to charge by information or indictment by their discretion. That shows them that there is a conflict between the state laws and the federal laws, and then you're going to say you cannot pay someone to break the law. You can't create a law that directs them to disobey their obligations constitutionally codified in the Constitution of the United States of America. And then you're going to take the four-page notice that I have here, and you're going to ask to have it be put on the record. All right? And ask to have it be put in the record. Okay? So this paperwork is going to be available on a Google Drive, and we'll provide a link to it. It'll probably be pinned to the top of this Facebook page. But it'll be on a Google Drive, and we're also going to get it up onto the website, www.tanawah.com. It will be easily found from within there. But you guys are going to take this then, and you're going to put this on notice. All right? So what it says that this is the notice of constitutional nonconformance. Honorable Commissioners, I'm writing you today to inform you of a situation that is of the utmost urgency and asking you to immediately take action to investigate the nonconformance of constitutional obligations that I have outlined below. Be advised that this dispute has been submitted to the United States Supreme Court and that Article 3 has been invoked by a United States citizen, demanding that the court fulfill the obligation of original jurisdiction as codified within the United States Constitution. As the constitutional obligation when Article 3 is invoked, because the state is named a party, the obligation is non-discretionary, non-delegatable, must be performed. Failure to do so would be a breach of constitutional obligation, resulting in a public wronging. Okay. As an advocate for the people, I hereby submit this action item request to you to immediately take action to address these direct willful deprivation rights secured by and enumerated in the Constitution of the United States of America by states subjected to the jurisdiction thereof. Let me be clear, I'm not trying to change the laws, rather I'm pointing out what the laws state, and that the ways in which they're being enforced directly contradict with what is specified. Therefore, I'm not trying to change the laws, rather I'm asking that we enforce them. If the laws state that something will be done in a certain way, then we must follow that way. Laws do not change arbitrarily, that is tyranny. Constitutionalism demands that the laws evolve only through suffrage. Therefore, it's up to the people to decide whether or not the Constitution applies to them and not a judge or the state. If, in the opinion of the people of the United States, any of the provisions or guarantees of the United States Constitution be in any particular way wrong, then let it be corrected by an amendment in the way in which the Constitution so designates, until, if and when that time comes, every single United States citizen is entitled to every single right secured by and enumerated in the United States Constitution, regardless of where they choose to reside within the jurisdictional United States. Notice of constitutional nonconformance. Currently, there are more than 700,000 people across the United States who are imprisoned on direct facial constitutional violations because their judgments derive from direct breaches of constitutional obligations by numerous states that are acting in direct willful defiance of the procedures and processes codified within the United States Constitution for the adjudication of crimes. Unfortunately, any judgment rendered as a result of a breach of constitutional obligation is unconstitutional because such judgments are tainted by the illegality of the way in which they are obtained. No judgment can be constitutional if they derive from an unconstitutional act. Clause 1 of Amendment 5 to the United States Constitution states, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of grand jury. That is clear. No person can be arrested or held to answer for a capital or an infamous crime without a presentment or indictment by a grand jury. Title 18 U.S.C. subsection 4083 defines an infamous crime as any crime punishable by more than 1 year imprisonment in a penitentiary. There are 13 states that outright do not conduct a grand jury proceeding at all, including the state of Washington. These states are choosing to charge persons for infamous crimes by information and not by indictment as constitutionally required. However, according to Title 18 U.S.C. subsection 555, information can only be used for other than infamous crimes. As a result, millions of United States citizens have been deprived due process of law and are now unlawfully imprisoned because the states failed to adhere to the procedures and processes required for the adjudication of crimes, resulting in judgments that are void and completely without force or effect under Civil Rule 60b-4. This systemic failure of the justice system to adhere to the agreed-upon code of conduct established by the majority goes far beyond these 13 states that are acting in direct willful defiance of the Constitution, because most other states permit the prosecuting attorney to charge by indictment or information as required by law, such as the state of Oklahoma or the state of Florida. Unfortunately, states do not have the power to substitute their own alternative legislation for the provisions and guarantees of the United States Constitution. And if they do, then the judges in every state are bound to thereby anything in the Constitution. According to the rules of civil procedure, rules must not conflict with statutes, nor impair the rights of the parties involved. Thus, a court has no power to create a rule which would constitute a waiver of a constitutional right. Or as stated by the United States Supreme Court in Miranda v. Arizona, where rights secured by the Constitution are involved, there can be no rule or legislation created which would abrogate them. One second there. Okay, which would abrogate them. Furthermore, sedition is defined as the speaking or writing of words, such as law established, to cause disaffection to the Constitution in order to procure its alteration in an other than lawful manner. Our Constitution is a rigid Constitution that can only be altered in accordance with the special amending procedures found within Article 5. Any attempt to alter it in any other manner, such as by legislation enacted by a state, would be an act of sedition by a body of men attempting to procure the alteration in an other than lawful manner. There is only one way to change the Constitution, and that is through an authentic act of the people, and until that happens, the Constitution is wholly with force and effect on all persons individually and collectively. When a prosecuting attorney chooses to rely upon a state statute to deprive a person of a right secured by and enumerated in the Constitution of the United States of America, that act is a crime called deprivation of rights under color of law, Title 18 U.S.C. subsection 242. And when a state judge chooses to hold a person over for trial without having the proper charging instrument as constitutionally required, that judge has entered into a conspiracy to deprive rights, Title 18 U.S.C. subsection 241. And when that judge then orders law enforcement to perform an arrest on an individual without the correct charging instrument as constitutionally required, those performing the arrest are complicit in the criminal conspiracy, and the crime of kidnapping has occurred, which if the crime of deprivation of rights under color of law occurs in conjunction with the kidnapping, the penalty is death as prescribed by law. This is a very serious matter that happens in every single state across this nation every single day, affecting millions of United States citizens, and it is imperative that the legislative branch immediately take action to correct the criminal acts of those enforcing and administering the laws of our nation unlawfully. In light of this evidence raised, as well as the supporting evidence that I could provide upon request for the deprivation of constitutional rights for millions of United States citizens, I implore you and appeal to your honorable nature to immediately initiate a public investigation of these criminal acts to ensure that those tasked with administering and enforcing those laws of this nation are doing it in compliance with the authority with which they're invested by law, and when it is determined that there's an abuse of delegated authority, that any and all liberties be immediately restored to all affected parties without delay or obstruction. Any person who pays any public official to act unlawfully are subject to criminal sanctions, which carry possible punishment of death as prescribed by law. I would advise this commission to immediately cease any further payment, benefits, or programs which permit any public official to act contrary to the supreme law of the land. While it is not the duty of a servant to question the motives of their superior, if he has reason to believe that his acts are unjust, he should obey his conscience and refuse to comply. Ultimately, the servant of a tyrant cannot take refuge in the excuse that he was just following orders. Therefore, in the wise words of President Abraham Lincoln, I do suppose that it will be much safer for all, both in private and public station, to abide by and conform to all those acts which stand unrepealed than to violate any of them, trusting to find impunity in their absolute immunity. Absolute immunity only covers civil liability, not criminal liability. So any deprivation of constitutional rights under the authority of an inferior state law or ruling is a crime, and no public official can avoid liability for violating, and the punishment as prescribed by law is one which you do not want to be enforced. Respectfully and peacefully. So you guys are going to take that. You don't have to read that, but you're going to take this and you're going to put it on the record, right? But you're going to need to have a discussion and outline it. So that's what we're going to have you guys do if you guys are willing to do it, if you're interested to do it, if you're able to. The key here is that you guys, you have the right to do it. First off, you shouldn't be scared. Never be scared of having a right. Don't be scared of criminals. These guys are all criminals. You know it. Don't be scared of them. Don't be scared of the proceeding. Go in there with full respect, knowing that you have the right to be able to exercise your political authority and exercise your political authority. Okay? You have 3 minutes. 3 minutes is more than enough. Take the script, read it to the council members, read it to the commissioners, and then place this notice on the record, right? Which is pointing to the case that I have, right? You want to point it to the case that I have. Don't try to do this for your own, right? You guys are doing this so we can point to this case, so we can force this in to that court and hopefully spur in a certified question as opposed to them, suspending the habeas. But now I circled something here because I wanted to come back to it. So it reminded me of something. So a lot of people say that you have waived your right. And again, I'm not speaking to you guys. I'm speaking to a very specific audience in this particular situation, because that particular audience, what they're saying is that you can waive your right to a preliminary hearing, right? That when you were arrested and you were brought to an arraignment, right, that you waived your right to a grand jury and thus you were charged by information. They say that you can waive your right to a grand jury in the federal court. They say that you can waive your right to a grand jury in the state court, that you can waive your right. And again, I'm talking to a very specific audience, but you all might as well hear as well. You cannot waive a constitutional right, you jackasses, because when you walk into that courtroom, right, when you walk into that courtroom, and you're already charged with the crime. You've already been arrested and charged, right? And they say, this is your first appearance. This is your arraignment. You're already in handcuffs. You're already in an orange jumpsuit. You've already been charged by that prosecutor by way of information. And then you say, oh, yeah, I waived my right to a grand jury. You've already been charged. The charge came before you waived anything. Therefore, you didn't waive it because that prosecutor charged you before you had the opportunity to waive the grand jury. Right? When you are present in the grand jury, because you weren't given the right to be able to be present to confront the hearsay accusations against you because the prosecutor denied you that right to operate the grand jury in secrecy and silence, right? Then they charged you by that indictment. You didn't waive anything, right? When you're charged by information, that charge happened before you waived any rights. The order for arrest came before you waived anything. Therefore, you can't waive it because the charge came before the waiver, right? You walk in that courtroom and you say, I waived my right to preliminary trial. You've already been arrested. You've already been charged. You're already sitting there. Prosecutors already violated your constitutional right by denying you by denying you that which restrains them, right? So you can't waive your right to a grand jury because you've already been charged at the point when you walk in there to waive your presentment to a public hearing or waive your right to preliminary hearing. So states, you're wrong. That's not true, because your prosecuting attorneys are charging before the preliminary hearing has ever been waived. Therefore, they were all charged by information, and you can't waive it after the charges already came because you already violated the right at that point in time. All right. So, again, according to the rules of civil procedure, rules, and these are, the courts create rules, judges create rules. Rules must not conflict with statutes, nor impair the legal rights of the parties involved in the dispute. Thus, a court has no power to create a rule which would constitute a waiver of a constitutional right. Rules cannot conflict with statute. So when the Supreme Court of the United States says, oh yeah, you can waive your right to remain silent, or you can waive your right to a jury trial and enter into this plea, no, you can't, because the law says that you're required to have a trial by jury. So if you, judge, are saying that I have the right to waive it, your rule is in conflict with the statute. It impairs the legal rights of the parties involved in the dispute. You're violating the rules of civil procedure because no rule can create a waiver of a constitutional right. All right, so we will provide the address to the Google Drive. We'll provide the address to get these documents, the scripts. What you guys need to do right now is you guys need to go out to your local website, go to your county commissioner, go to your city council, find out when the next hearing is. They usually hold them, lots of places hold them every single week. Make sure it's a hearing. Go into the agenda, right? Because when you go into the agenda will be available a day or two, even a week before. Go into the agenda, download the agenda, and make sure that it says that there's public hearing, right? That they have a hearing. And if they have a hearing, then you guys show up there that day of that hearing, right? And you get your 3 minutes. They're going to say, well, you know, who wants to speak? And you just stand up and say, oh, well, I've got something to say, right? And you'll go up to the podium at the allotted time. They'll give you 3 minutes, and you'll read the script, right? And then you'll say, I want to put this on the record. And then you'll take this over to the county clerk or the city clerk. You'll give it to them. It will go on the record. And then what we need you to do then is we need you guys to notify us, either me or Justice Without Limits, because we're populating a map of the United States so we can keep track of where these notices have been done. And then you guys, if you want, you can even, all the video is available. Once you put something on the record, it's available. You'll go to the website, screenshot it, whatever, upload it, share it, make everybody know, and just spread this far and wide. Okay, guys? So that's what I would recommend. So what are some questions?
What happens if we get arrested?
So one of the things that you're going to do is you're going to do it in a very respectful manner. And you're not going in there with signs, okay? You're not going in there saying, you guys, you're going in there and you're taking 3 minutes. I can't say what would happen. What I can say is that I'm going around the country and I'm doing this to attorney generals. I'm doing this in judges and to judges and Supreme Courts, and I'm not getting arrested. So if you guys are getting arrested for some reason, it's because maybe you're doing something a little bit wrong, right? Maybe it's not being the right approach. So you don't stand up to them, right? Because they have power. You want to stroke their ego, you guys. I mean, it is what it is. You want to stroke their ego. And you want to call them honorable, right? You want to say, yes, ma'am, yes, sir, and yes, you're honorable. Let them cross the line, right? But give them the respect that they believe that they have, and you won't get arrested for anything, right? You have the right to be able to come up and step up and say, but you're going to say specifically, I am a civil rights advocate, right? I'm a civil rights advocate. And this case is preparing to be argued at the United States Supreme Court. That makes them shut up. They don't want to mess with the civil rights advocate. So I can't say, but if you guys get arrested, it would be without lawful authority. Because when you read something that says that, that here's what the Constitution of the United States of America says, the state of whatever is not doing that, and I'm here to inform you that you are paying these people to break the law, and that's a crime, and criminal sanctions could be brought against you if you guys continue to do this. So I'm simply asking that you guys, review the Constitution, and let's direct your agents to act in a lawful constitutional manner. That's pretty simple. That's very respectful, and it's easy. But what that does is it draws a line in the sand, you guys. Draws a line in the sand. It says, here's what the law states. You guys are operating outside of that law, and now being made aware, you can either continue to act unlawfully, in which case you're a criminal, traitor, or you can return to established rule of law and obey the law and not be a criminal, right? So I can't say, but if you think that you're going to be arrested, then maybe you're not the right person to be going in and doing that. Maybe we'll, because I can tell you that I've done this numerous times, and I haven't been in any danger. We did it in Boston. We did it in Fairfax. We did it in Birmingham, Alabama. We did it in Carson City, Nevada. And, so I don't know. I think the closest I ever came to getting arrested was probably in Maryland when the Supreme Court clerk of court said that I was threatening them when I said that these are capital offenses, and I was like, no, that's not. I'm not threatening. But now we're done. Conversation's over. Because if you're gonna say that I'm threatening you, then conversation's over. You already have service. Here's paperwork. We're done. You just walk away. Right? Don't stand up to them. Right? Let them cross the line. You don't have to cross it. Okay.
Can people still send their affidavits?
Please continue sending affidavits. Guys, until the day that every single crime is reported that this government is committed against people of the United States, I will continue to accept those affidavits, man. 100%. Like every single person that has had a crime, Scripture says that we are going to expose every single lie. So yeah, keep sending those affidavits. We will continue to receive them until every single crime has been reported. All right, every single one. And it will become more applicable as we move on. So right now, today, there's still steps that have to happen. Let's say that next week they agree to receive these pallets, right? And they make plans and we schedule it. And let's say that next Wednesday we're delivering all these pallets to them, right? So we delivered 13 pallets to the United States Supreme Court next Wednesday. Let's say that that's what happens. As of that moment, what would happen is that then we would get a docket number. Here's a docket number, okay? Once we get the docket number, it's going to be about 40 days before we would have oral arguments. Well, remember, they're on summer recess now, okay? That doesn't mean that they don't have to have oral arguments, because 2254, the writ habeas corpus, places very, very strict and stringent time limitations on their response, right? So just because they're in recess doesn't mean that if a writ habeas corpus doesn't come today, they don't still have to make a decision in 40 days. That a recess be damned, because the law says you only have this much time to respond. That's why another reason why we're using the writ habeas corpus is it's not typical litigation. It is a judicial relief, which means that all we have to do is show that they had an obligation and the state participated in the deprivation of that right, of that fundamental right without lawful authority. So we got about 40 days, okay? So we're going to deliver the paperwork, receive the docket number. That's when the clock will start ticking, and that's when we'll actually start the final term, because there's going to be a victory lap around the country. We have 40 days. And once this is docketed, once we have the docket number, cat's out of the bag. That's what they're trying to prevent happening, because the moment that there's a docket number, then everybody's going to know about this, and they're going to say, oh, wait a second now. These states are 700,000 people are being held against their, in violation of their fundamental rights. This is going to be huge, and it's just going to explode, That's what they don't want. That's the last thing that they want is for this to hit the docket and them to have to let everybody know that this is what's going on, because now it's going to bring attention to the reality and legitimacy of this issue. That's why they're ignoring it. That's why they don't want to docket it. That's why the clerk of court refused to docket it last time I submitted in 2023. Wouldn't docket it because the moment's on the docket, now we've got all these law firms and everyone else to be looking at it going, holy shit, that's huge. Let's go after it. But once we get the docket, right, we're using the 2 million affidavit, the 13 pallets of paper we have right now, we're using that as the mechanism to bring it in and say, here, original jurisdiction, give us a docket number. Once that starts, the victory is a foregone conclusion, you guys. Foregone conclusion. The court has to side with this. They have to. For a number of different reasons, and we won't even go into that. But once it's docketed, we got 40 days. That's when we're going to start the actual term. And that will be when we go to these states and we hold these press conferences and the press actually shows up, right? And so that's 32 press conferences at 32 state capitals over the course of 40 days, ending back in Washington, D.C., where we will deliver oral arguments on behalf of people of the United States, okay? So that's the tour. That's the final one. That's what we're anticipating right now. There will be another trip around the country, but what I'm saying is that you guys still have time, because when we do win, the first thing that's going to happen is that anybody that is already within the procedural situation would receive what's called vicarious relief, okay? Because with a habeas corpus, right, what we're doing is we're putting everybody into the same exact procedural situation. That's why the affidavits are all exactly the same, right? So this first part here, it establishes the crime of deprivation of rights under color of law. Title 18, subsection 242. The second paragraph establishes the conspiracy to deprive of rights. Title 18, subsection 241. So what we're doing is we're putting everybody in the same procedural situation so we can litigate them all at once. Because anybody that's in the same procedural situation, if one petitioner overcomes the procedural situation, all petitioners overcome the procedural situation. So if the situation goes like this, someone portraying themselves as a prosecuting attorney did deprive someone of an indictment by a grand jury when they charged them by information, not by indictment, there's the base crime, deprivation of rights under color of law. We don't need anything else. That's sufficient to establish that someone deprived someone of something that they're guaranteed by the Constitution of the United States under an inferior state law. We don't need anything else. All 50 states, all 700, all 2 billion, all 5 million, 70 million people have been charged with. Doesn't matter. They are all exactly the same. Someone charged you improperly by relying upon a state law to deprive you of something guaranteed by the Constitution of the United States. Second part is that someone portraying themselves as a judicial officer did conspire by and between that person that charged incorrectly and that person going out and performing the arrest when they held the victim over for ransom or for the infamous crime without an indictment by a grand jury as required by the Constitution of the United States of America. That establishes a conspiracy, and we don't need anything else, because what we do know, right? We know that there were probably other judges involved, right? We know that there were probably 3 officers that arrested you, not just one. But what we do know as a material fact is that there was a prosecutor, there was a judge, and there was a police officer in every single one of your cases. Now, if there's more people, well, that would come from an investigation. But the material fact is that a prosecutor charged you improperly. A judge conspired with that prosecutor and law enforcement officer when they held you to answer. That's the material fact. And that material fact is the same procedural situation for 70 million people who have been charged with or convicted of a crime by the United States justice system or system subjected to the jurisdiction thereof. Every single one of you can submit that same exact affidavit, which will place you into the same exact procedural situation. And now, if I can argue that the Constitution of the United States of America requires an indictment by a grand jury and that you were denied it when you were not charged with it, if I can win one single argument, one of any one of the 2 million, if I can win one argument, then every single petitioner in the same procedural situation will receive vicarious relief. All right? Because if you can argue for one, you can argue for all. That's the amazing part about a habeas corpus. This is the great writ. This is why government hates it. This is why nobody wins it. It's because they do everything in their power to make you not know how it works. You can class a habeas corpus. It's extremely rare, but it was done last in 2004 by the ACLU for Rasul versus Bush and all of the prisoners down in Guantanamo Bay, Cuba. And we're doing it again. I'm doing it again. So in 2004, the ACLU stepped up and they filed a class action habeas corpus on behalf of all the prisoners being held down in Guantanamo Bay, Cuba, in violation of their fundamental rights because the United States of America, the federal justice system, acted in a manner to deprive them of their fundamental rights to be able to challenge the hearsay accusation against them in a fair and neutral proceeding in front of a fair and neutral decision maker called a grand jury. Now I'm filing the same thing on behalf of 2.9 million prisoners that I know are being held in violation of their fundamental rights because 99% of them were not present in the grand jury to confront the hearsay accusation against them, or 700,000 of them never even received an indictment by a grand jury, were never given the opportunity to confront the hearsay accusations that are against them in a fair and neutral proceeding in front of fair and neutral decision maker, third party. So, so we can file the habeas corpus on behalf of these prisoners, and that's what we're doing. So, please continue to send the affidavits in. If you guys are prisoners, please continue to send them in. But I'm at a point now where I can do the rest. Whether I can do the rest from here on out, I can do the rest on my own. Everything from this moment forward, I can handle the rest of it, including the argument. The only thing I ask or the only thing I need is you guys to support financially getting there. Because you guys know I work for you. I serve you guys. I'm here doing this because I gave up my life. I gave up my job. I gave up everything so that I could fight this battle for you guys. And that's what I'm doing. So, if you guys want to support, then we can make this happen quicker. But I work for you. If you guys like my service, then please donate and please help us get this done. Because that's honestly the only limitation that I have at this point in time. Only limitation is financing. The finances, that's it. So once we get past the 40 days, or once we get the docket, we'll start the 40 days. I'll be back out on the road. We will have discussions because once this is docketed, every single state is going to want to talk about this issue. We'll end back here in Washington, D.C., and then we'll have oral arguments, and then we win. So I can't tell you what it's going to look like afterwards because, this is a pretty big deal. This is a huge impact to their operation. This is a lot of unconstitutional judgments that have to be overturned. This is a lot of prisoners that are going to be going home. I don't know what it's going to look like. All that I know is that the moment that it's deemed that their conviction is unconstitutional, we must restore the individual back to the point in which their liberties were deprived, which means that if the constitutional violation occurred at the moment of the arrest, we must restore that person to the moment of the arrest. Everything is gone. There's no magic time machine. We're not going to get you your life back or whatever, but what they have to do is they must return you to the moment in which the state or government breached their constitutional obligations, which means that they must return you to a state of freedom. Because the arrest, the detainment was unconstitutional, they must return you to that point. Okay, now, I'm also going to say that there are dangerous people, you guys. I have never Not one time have I ever said that we're going to release dangerous people out to public. Never. We got liars and idiots and people that are just trying to attack my character. They say, oh yeah, he wants to release all these dangerous murderers and rapists. I'm not saying that. I have never once said that. I'm not an abolitionist. I believe in the justice system. I know we need prisons. I know we have people in a dangerous society. I have never, ever, ever said that we're going to release dangerous people to the community. Never. Anybody that says that I did or do, they're just simply trying to advance a bullshit lie narrative because they're jealous of me or whatever else. I can't say because I can't go into their mind, but obviously I'm going to presume that it originates from their jealousy because they're not intelligent enough to be able to come up with their own idea, so they want to knock this one down. But I'm just going to throw that out there. It's mostly over here on Facebook, so I'm going to point it over there. But so the thing is that I've never said that we're going to release dangerous people. But what I can say is that most criminologists across the world agree that only about 4% of our prison population is a danger to society. 78% of the people in prison are drug-related offenses. That's not a dangerous person. That's a hurting person, right? And you treat a hurting person differently than you treat a dangerous person. You heal them from the trauma. You heal them from the hurts. So 78% of people, we just simply deal with them differently than we do by force them into involuntary servitude so we can directly benefit from them in a state-run for-profit business, right? That's not the way you deal with that, is enslaving them. No. So that's 78% right off the board, right? That's easy right there. Take those people, let's put them into a hospital, and let's treat them for the trauma that has been inflicted. Now, between 78 and 96% is property-related crimes, right? This is embezzlement. This is theft. And that's not dangerous behavior either. That's aberrant behavior, right? That's behavior that we want to correct by leadership. That's how you deal with aberrant behavior. It's not dangerous behavior, it's aberrant behavior, right? So now we get to there by simply better leadership, right? By helping them become freestanding, by helping them understand that this isn't good behavior because our government's going to not be committing that same exact behavior, leading them in that direction. If you want to correct embezzlement, then don't be stealing from the Social Security Act and paying states to steal children or funnel money to Ukraine. Don't do that, right? Because otherwise you're leading the people into acts of embezzlement yourself because they're going to learn from you, leaders. So only a very small portion of our society or of our prison population is a dangerous society. I have never said that we need to let them out, but we do need to identify who those people are, right? Government, you have to do this. You have to figure out who those people are. You need to figure that out. You need to do a risk assessment on every single person if you're not already doing it so that you can know who is a danger to society and who is not. And we're going to get rid of the people that are not a danger, and we're going to deal with the issue of morality as a matter of public health and not as a matter of punishment. So I have never, ever, ever advocated for the release of dangerous people. Don't get me wrong. I've never said we're going to do that. But so I can't say what exactly is going to happen, but what I can say is that if a judgment is unconstitutional, then that unconstitutional judgment must be addressed. I don't care who they are. I don't care what they did. I don't care how long they're sentenced for. I don't care if the judgment is unconstitutional. You may not keep that unconstitutional judgment in place because it's unconstitutional. But I'm not saying release dangerous people into society. What I'm saying is you will transfer them from a criminal incapacitation into a civil incapacitation. And you're going to put them into a hospital. And when that hospital deems that, if they ever deem that they're safe to be able to be released back into society, then we will allow for the medical profession, right, to be able to address this, because we're not going to allow the Attorney General to continue to profit off of the direct involuntary servitude and punishment of the monsters that the Attorney General himself is creating through the illegal and unlawful acts of his own agents. That we're not going to do. You're not going to continue to access the SQB of the children that you robbed from their parents, or the SQB of the people that you take into your custody as an adult and hold there because you want to be able to profit off of your illegal acts. Attorney Generals, we're not going to allow that anymore. Bar Association, we're not going to allow that anymore. So the issue of morality is a matter of public health, and we're going to treat it as such, and we're going to make sure that those that are hurting within our society gets the treatment that they need, and that's the only thing that I've ever said. I have never said anything else, okay? But if their judgment is unconstitutional, it will not stand. It will not, because this is an all or nothing situation. If we allow for one judgment to remain unconstitutionally, then we will not have resolved this issue of criminality or slavery. And so we must rip this out from its core. We must rip it out at its foundation, from its roots, and get rid of this entire slavery institution once and for all, completely, with finality. Nothing will remain in place as it stands today. So yes, please continue, Senator.
Can the Constitution or the Bill of Rights be suspended?
Well, no, it can't. Now, a lot of people say, well, the Insurrection Act or Emergency Powers Act. No, you guys, no. Those are acts of Congress. Acts of Congress, it cannot be in conflict with the Constitution of the United States of America. Okay. So what's the purpose of our Constitution? The purpose of the Constitution of the United States of America is to establish rights, limit powers. People have rights, government has powers. In some cases, the state powers are limited, right? In other cases, federal powers are limited. In more cases, both powers are limited, but the limits of power are designed to preserve the individual liberties of the people. So in COVID, what happened was that the governors, they relied upon what's called the Emergency Powers Act, right, in order to create all these deprivation rights. Well, if you go in and you read the Emergency Powers Act, what it says is that the governor or the president can suspend statutory obligations in certain emergency conditions, okay? That's in the preface. Go into the preface, go into it. You can see that the governor or president, the executive officer, can suspend statutory obligations during certain emergency conditions. Guys, the Constitution is a statute. It's the highest form of statute, but it still is a statute. That statute creates obligations. Obligations to government. Such as no person shall be held to answer for capital or otherwise if it's crime, unless on presentment or indictment of a grand jury. That's an obligation that they must have it indicted by a grand jury before arresting and holding you over for that offense. That's what it says. That's the obligation. So if government can suspend statutory obligations, what they're saying is that government can suspend the Constitution. So martial law is, you fall under the UCMJ, Uniform Code of Military Justice. Now you've got generals that come in and control these areas, and because they suspended the Constitution, and now you're subject to military tribunals and all the rest. And that's what martial law is, right? I mean, is this ringing a bell for you guys? So the only question I have is, why would our founders and forefathers create a supreme law of the land that guarantees the rights of the people, but then in that same law permit those that are to be bound and restrained by such law to be able to exceed such law by their discretion? If government could suspend the Constitution, then to what purpose is the Constitution? Why would we create something that guarantees our rights and protects us from the powers of government if those powers can be suspended by the president or governor's will, whenever they want? No. The Constitution cannot be suspended because nowhere in the Constitution does it permit such suspension. Constitution doesn't say, President, you can abuse your powers to suspend that which restrains your powers. It doesn't say, governors, you can abuse your powers by suspending that which restrains your powers. And it certainly doesn't say, Congress, you can abuse your powers by creating an act that permits someone else to suspend the obligations that restrains you. The Insurrection Act is not valid because it's unconstitutional. It suspends the Constitution. The Emergency Powers Act is unconstitutional because it goes against the Constitution. It suspends the Constitution. Martial law is unconstitutional because it's a suspension of the Constitution. It gives the president allegedly the power to suspend that which restrains his power. And our founders would have never created such a document. Never. So no, under no instance, unless by an authentic act of the people in accordance with the special amending procedure of Article 5, can the Constitution and the Bill of Rights ever be suspended.
Okay, regarding grand jury indictments, if the grand jury does not allow you to be part of the hearing, is that still a valid outcome?
Nope. No. So again, like there's two things. One is the absence of the indictment by a grand jury. More than 700,000 people that have been arrested and held and detained without an indictment by a grand jury, charged by information. If you guys can believe it, that's the low-hanging fruit. Low-hanging, like that's the easy ones. 700,000 people that we can easily get out by the work that I'm doing overnight. I mean, literally overnight, because where was the indictment by grand jury? It was required prior to arresting, hold them over. You didn't have one. You charged by information. Now, 99% of all grand juries, they don't permit the accused the right to be present to confront the hearsay accusation against them. The prosecutor runs that grand jury in silence and darkness. Is that valid? It's a question. No, not at all. The reason why is because the purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor. The purpose of the grand jury is to protect the accused from the prosecutor. That's its purpose. Okay, so if the purpose of the grand jury is to protect the accused from the prosecutor, then why is the prosecutor denying the accused the right to be present in the proceeding that exists for their protection from the one denying you right to be present? If it's the prosecuting attorney that decides by their discretion whether or not to have an indictment or information, the charging instrument, well, the purpose of the grand jury is to protect you from this prosecutor who's denying you it. This shit doesn't make sense, right? Doesn't make sense. But the reason why you have to be present in that grand jury, one is a case called Hurtado versus California, Hurtado versus California. Now, in Hurtado, if you were to read about it, it would describe the whole process of a grand jury. And it specifically states, this is from 1884, by the way. So 1884. And in Hurtado, they said that the accused is present, has the right to call and cross-examine witnesses. So in 1884, they described the grand jury process, and they specifically said that the accused has the right to be present and can call and cross-examine witnesses. So the accused was supposed to be present. Even by the Supreme Court, by their own description of the proceeding, they were supposed to be present in the proceeding that protects them from the person that's denying them the ability to be present to protect them. It doesn't make sense. But let's dig a little bit deeper into law. So the Civil Rights Act, which is the backbone of Title 42, and that's where the enforcement statute of 242 and 241 comes from, the ones that we're relying upon for this particular litigation, the criminal statute. So Title 42, subsection 1981, what it says is it says all persons within the jurisdiction of the United States shall be entitled to fair and equal benefits of all laws and all proceedings. All persons. And it doesn't say citizens. It says all persons. Remember, all persons. It says all persons within the jurisdiction of the United States shall enjoy fair and equal benefits of all laws and all proceedings. Okay? So, when you have a grand jury, you have someone that comes in with an accusation. They present that accusation to this body of men. They say, hey, here's my accusation. Now that body of men then take that single set of information, because the other side was unrebutted. It's an unrebutted accusation. They never gave the opportunity to rebut the hearsay accusation against them. And so then the grand jury says, yeah, well, there's sufficient probable cause because there's nobody here to counter that claim. We have to assume that's valid, so it's unrebutted. So then they issue an order for arrest. They issue a true bill. They say, here, you're go out and arrest this guy because this person said something happened and no one was here to rebut it. No one was here to counter it because the prosecutor obstructed justice by denying the opposing party the right to be present to confront the hearsay accusation against him. That is called charging by information. If you were not present in the grand jury to confront the hearsay accusation against you, that is not an indictment. That is information. Because an indictment requires both sides to be able to present it. Because the moment that the prosecutor conspired by and between the accuser to deny the accused their right to be present to benefit from the very proceeding that exists for their protection from the one denying them the right to be present, that's conspiracy to obstruct justice. Two or more persons conspire for the purpose of preventing any party in any cause from participating in said cause commits that crime. And if you commit a crime in order to secure an indictment, by that crime there is no indictment, therefore you are charged by information. 99% of the people in prison right now today would fall under information, not indictment. So if you weren't present in that grand jury, you were denied your right to be present by the very person that proceeding was there to protect you from. And by the criminal act that they committed, obstruction of justice, conspiracy to obstruct justice, that voids the indictment, which means that you were charged by information from the prosecutor. Because it is still an irrebuttable presumption of guilt. They did not give you your right to rebut the accusation against you because that prosecutor obstructed justice by permitting his client, the accuser, the right to benefit from the proceeding, but denied you your right to equal benefit of that proceeding in violation of Title 42, 1981. So, yeah, if you weren't present, you were still charged by information.
And that doesn't matter, the time frame. If it was 10 years, 20 years ago, it doesn't matter.
There is no statute of limitations on a constitutional violation. The maximum law is any act unconstitutional at the beginning cannot become constitutional over time or by subsequent legislation. If government commits an unconstitutional act, then that act can never, ever, ever become constitutional. So when we use the constitutional violations, right, and we don't use rulings or misconduct, or when we rely upon the constitutional violations, there is no statute of limitations. Because if the judgment was unconstitutional and derives from a constitutional act, then there is no statute of limitations on that particular breach of obligation. That's why we're relying upon the enumerated constitutional right to show that they have acted unlawfully, and it doesn't matter how long it's been, because there is no statute of limitations on their breach of obligation. Perjury doesn't just last for 3 years or 5 years or 10 years. No, you committed perjury, you're done, cooked. From the moment you committed perjury on it, nothing's valid ever. You had an obligation and you didn't fulfill it. You can't hide behind some bullshit statute of limitations, because when you didn't fulfill your constitutional obligation, by that failure to do it, it can never become constitutional. Any act unconstitutional at the beginning cannot become constitutional over time or by subsequent legislation.
Okay, we have one more question. How about, let's see. Does the same apply in family court where you were never charged, but you still went in front of a judge with information to remove your child?
Yeah. So this is the parallel that I keep on trying to deliver to you guys, is that tyrants will always act the same. Because they're always trained to act in the same way. So once you identify the standard operating procedure of the tyrant, then you can presume that all the tyrants are all being trained to act the same way. Okay? And this is why I'm tying these two things together. Because when you look at the criminal issue is really easy for me to discuss because it's so black and white and so plain. But it's not as easy for the familial side, for the child side, because in order to understand that you have to look at the behavior of the judge and what they're being taught over here. So over here on the criminal side, you are presumed to be guilty based upon the mere fact of being accused of a crime. Information. Prosecutor got the information from someone that accused you of committing a crime. Therefore, you're going to be arrested. You're going to be taken into jail. They're going to put you through these deprivation tactics. They're going to keep those in place until you finally admit that you are what they say that you are because they have the information on you. Right? That's the whole Guantanamo Bay, Cuba. Right? That's where I started. So that is what they're doing. They are being taught to presume that you are guilty based upon someone accusing you of a crime. So now it's guilty until proven innocent. It's not innocent until proven guilty. It's the opposite. Now, you have the right to be present to confront the hearsay accusation against you. Therefore, the opposite of that would be you're being denied the right to confront the hearsay accusation against you. All right? If the prosecutor has to prove that you're guilty, but now you have to prove that you're innocent, that's a shift in the burden. So everything that they're doing is the exact opposite of what they're supposed to be doing, right? They're going to judge-made rulings to determine whether or not you have a constitutional right, not the Constitution. Therefore, judge-made rulings is the foundation, not the Constitution. Everything is upside down. Everything is wrong. It's the opposite of what it should be. So the reason why I say that is because if you're being presumed guilty and being arrested, right, on an irrebuttable presumption of guilt because you were charged by information and you weren't given the opportunity to confront the hearsay accusation against you, that's the standard operating procedure for judges on the criminal side. But the criminal and family judges are interchangeable. So if that's the standard operating procedure for a criminal judge, then over here on the family side, you are presumed unfit based upon an accusation of being unfit. Now you have to go out and prove that you're fit, right? Because it's no longer a state that has to prove that you're unfit. It's the same operating procedure. So if you have the right to be innocent until proven guilty, that's the way that the judge is supposed to treat you, and they're not, then over here on the family side, you must have the right to the presumption of being fit until the state has proven that you're unfit. You have the right to be free, right, until such time as you've been found and determined guilty. Then, therefore, over here, you must have the right to remain a family and have your children until such time as you've been determined to be unfit to be a family, whatever. It's the same thing. It's the exact same standard operating procedure. So when we use the argument for the irrebuttable presumption of guilt on the criminal side, we can easily mirror it over and show that you have the irrebuttable presumption of unfit on the family side because the judges are all being taught to act in the exact same way. Exact same way. So we use the criminal matter to show based upon, Blackstone knowledge, based upon the irrebuttable presumption of guilt, based upon a number of historical things because the family court is a fairly new animal within the judiciary. So we use the historical stuff because irrebuttable presumption of guilt is well known. It's written in Blackstone. They talk about the process. There's all kinds of information on it. But we can show the behavior where you're presumed guilty due to a breakdown due process because the system is focusing on speed and efficiency instead of established procedures and processes, we can bridge that across to the newer element of the family court and how the judges are acting the exact same behavior, the exact same way.
That's it.
Okay. All right. All right, guys. We're gonna take off here. We could definitely use the donations, guys. Don't stop donating. I can handle the rest of this. I can finish the rest of this. But you know, as I said before, you know, I serve you guys. I serve you guys, and so if you guys want to see me successful, then we need your support. But from here on out, I can handle the rest of it. So again, going back, if you guys are only here, you just got here, whatever, you can go to YouTube and go back to this video. You can watch we can watch it there. You can watch it on Facebook. I will break this up into lots of different shorter videos within TikTok, and yeah. So if you guys want to donate, if you believe in the cause, if you believe in the words I'm saying, if you want to get behind this, then we have Cash App, Chime, Venmo, PayPal. They are all exactly the same. It's We Shall Be Free. It's WESHALLBEFREE. We Shall Be Free. And we do need the support still, right? We're getting close, but we do need the support. So please donate, and I will read through all of this. I see there's a whole bunch of questions here, guys. I'll read through it. I'll try to respond. And over here on TikTok, I'll read through this. I'll respond as I can. Guys, continue to send in the affidavits. It's not done yet. I will provide before the end of the weekend here. We'll have the notice for your city council and your county commissioners. We'll have it available, as well as the script that you guys need to read. It will be available probably on the website www.tanawah.com, as well as also on a Google Drive. We'll provide that is available. So please continue to go out to the social media, to my pages, and keep monitoring them, because we'll get that information out. But what you guys need to do right now is go out to the website, to your local city council, to your local county commissioner, find out when the meeting is, get ready and plan on being there, whatever you got to do, and plan on reading the script into the record, and then filing this notice on the record as well. And let's put them all on notice to ratchet this up. All right, guys? So please continue to like, follow, share. Guys, over on Facebook, TikTok, you guys have been falling behind, because for some reason my Facebook account, after years and years, has just exploded. And Facebook, you know, I appreciate all the shares that you guys are doing. It's amazing. You guys have been getting me like hundreds and thousands of views on these videos. That's something I've never had. So Facebook, thank you guys so much. TikTok, I know you guys are going to pick it up. But for some reason, you know, TikTok I've been battling with them, because I don't know, the algorithms have just been tearing me apart. So please continue to like, follow, share. Please comment if you can. But what gets these videos moving the most is reposting them. So over here on TikTok, if you want to repost, you'll go down here in this area right around here. There's little 3 buttons. You tap on those 3 buttons, and then up over here into this area right here, there's a little orange circle, right? It says repost. All you do is tap on that. That puts it out into your queue, sends it out amongst your followers. That single-handedly is the way to get these views up the highest. So the more you repost, the more it gets back on the For You page, and the more, you know, people end up viewing this. So if you guys can, please share everything you can. Over here on Facebook, if you guys want to repost, you know, you will go over here in this area, you'll tap on this little arrow, and then it'll pop up saying, with a list of options down here, and you'll just say, post. And then just say, hey, you don't even have to say anything, but just repost. That puts it out into your page. It shares it with your contacts, and that single-handedly is the way that we get the most views. So please repost, please share, and thank you guys so much for everything you've done to get us to where we're at right now. and just keep an eye on these protests, right? And I fully support them, you know, but I'm not going to be around them personally. But let's be really careful about allowing the administration or the government to lead us into a place that we don't want to go because of their underlying motivation of suspending the privilege of habeas corpus. We do not want to have to go into a battle against the suspension of the habeas, because I don't know how we're going to win that, right? Because the Constitution does permit the suspension of the habeas corpus in actual times of rebellion, which means that I don't know how we can argue that other than the argument that I'm preparing, which is it's the government that's in rebellion, not the people. As long as government is not following the laws, government's the one in rebellion, and the people can't be held accountable, because according to John Locke, that when you war against the Constitution, you place yourself into a state, or sorry, when you reduce the people to a state of enslavement, you are warring against the people, and the people have the right to reclaim their liberty and restore their original rights. So the people can't be in rebellion when we're simply assuming our original rights because of the breach of obligation that government has done in failure to fulfill the constitutional obligations. So it's the government that's in rebellion, not the people. But I don't know how we're going to argue that, because if they do suspend the privilege of habeas corpus, such as they can under Article 1, it's going to be a very, very uphill battle for us to be able to, because they would be doing it with the specific intended purpose to make this go away. Okay? So thank you guys so much. God bless, and have a great rest of your day. And please get out and donate. Thank you guys. Thanks, Facebook. Thank you. Thank you, YouTube. Appreciate it, guys. Thank you. And thank you.